my senior brothers, Justice Sikri, Justice Ashok Bhushan, my senior from school and college, Mr. Amitabh Kant, Sumant, overactive and over-enthusiastic as always, and Mr. Atkins from the Insol International. Very good morning to all of you. At the outset, I would like to thank the Insolvency Law Academy for inviting me to this inaugural conference, which I'm sure with the 2 invigorating days of intellectual rigors and technical discussions and fruitful engagements will produce the requisite for which all of you have assembled. India's economy has been growing since the early 1990s, leading to an expansion of the credit market. This has resulted in an increase in non-performing loans and assets. To solve this problem, the Insolvency and Bankruptcy Code was enacted in 2016, primarily to serve 2 purposes. First, to ensure that debtors take sound and practical decisions, and second, to give financially ailing corporate entities a chance to rehabilitate and continue their businesses. The IBC essentially consolidates the laws relating to insolvency resolution of companies, partnership, and individuals. Hence, the implementation of IBC in India marked the beginning of a new era that completely overhauled India's insolvency regime. In its 6 years of existence, the IBC has proven to be a dynamic code which constantly adapts to the realities of the Indian society. For instance, the IBC shifted India's insolvency regime from a debtor in possession to a creditor in control. Thus, the balance of power shifted from the promoters of a company to the creditors, resulting in healthy decision-making by the promoters. It also introduced substantially reduced timelines and intermediaries like resolution professionals. The winding-up process of companies has become significantly more efficient since the promulgation of the IBC. Faster resolution of cases has spurred M&A deals in India, as bidders can more easily acquire stressed assets at lucrative prices, and a number of companies are closer to the conclusion of their resolution processes. It would be a fair credit to India's rise in the ease of doing business index to the IBC, as well as to some extent, India's rank has gone from 142 in 2014 to finally 63 in 2022. Due credit for which should be given to the IBC. In my opinion, IBC has also had a big role to play in India's new startup culture by creating a conducive environment for budding entrepreneurs. The IBC has evolved vibrantly through amendments, rules, regulations, and judicial interpretations. The Supreme Court held in its landmark decision of Innovative Industries that once an insolvency professional is appointed to manage the company, the erstwhile directors who are no longer in management cannot maintain an appeal on behalf of the company. The Supreme Court continued to bring its clarity on issues of rights and powers of stakeholders in insolvency proceedings. For example, in the recent case of Sundaresh Bhatt, the Supreme Court opined that the IBC would prevail over the Customs Act to the extent that once moratorium is imposed under the IBC, the Central Board of Indirect Taxes and Customs had limited jurisdiction to assess, determine the quantum of custom duty and other levies, and did not have the power to initiate recovery of dues by means of sales confiscation as provided under the Customs Act. Currently, the government is in the process of proposing changes in the IBC in order to reduce the hardship of home buyers caught in time-consuming legal battles with real estate developers. We must appreciate that these battles are not only about colossal amounts of money involved in these matters, but about the dreams and hard-earning saves of those home buyers. As per the government's suggestions, if an application is filed against a real estate developer having multiple projects, proceedings may be initiated only against a specific project that has defaulted. This suggestion would, in a way, be a formal recognition of the concept of reverse CIRP, which allows promoters to infuse funds into stalled projects where the focus is on the completion of the affected project rather than revival. Hence, even if the company is legally under insolvency, the economic solution would be limited to the affected project. This concept of reverse CIRP was propounded in February 2020 by the NCLT in the matter of Umang Real Tech. I must admit that in these early years of implementation of the code, we are faced with complex questions that require authoritative and conclusive answers. But this provides not only the judiciary, but also the professionals an opportunity to contribute towards laying an infallible foundation. The conference highlights major aspects of insolvency regime, which are important not just for India, but also globally. For instance, the insolvency process is highly reliant on the commercial wisdom of the Committee of Creditors, because of which they are expected to perform to the highest standards. In the Satish Kumar Gupta case, the Supreme Court reiterated the limited judicial review available with the adjudicating authority and discussed the hands-off approach that should be adopted. Hence, I believe that the panel discussions on Code of Conduct for Committee of Creditors in this regard is not only integral, but also timely. Further, I am glad that the Insolvency Law Academy has chosen diversity and representation in insolvency as one of the topics for discussion. The diversity in our society must reflect in all fields of life, as it brings on the table varied views, experiences, and wholesome solutions. I believe the main issue in ensuring successful representation is an unconscious bias. This has led to vicious circles where, on one hand, newcomers are not given the platform to showcase their talent due to their lack of experience. But on the other hand, these newcomers cannot find that experience if opportunities are not granted to them. Hence, I look forward to the following: how the discussion on bringing diversity into the procession of insolvency along with gender inclusivity are dealt with by the panelists. While I commented on the NCLT and the NCLT for doing a tremendous job in managing insolvency disputes, I would like to state here that 3 factors that need to be considered when dealing with any insolvency dispute. First, insolvency proceedings envisage limited court interference. Second, Indian courts and tribunals are overburdened, leading to heavy pendency. Third, the commercial parties in such proceedings would want to save time and reputation. In this context, I appreciate Insolvency Law Academy's efforts to bring forth the panel discussion looking into the future, pre-insolvency framework and mediation. I have always been an ardent believer in potential of alternative dispute resolution procedures, along with Justice Sikri. As a confidential and voluntary process, mediation in insolvency proceedings offers a distressed business relative protection from public scrutiny at a fraction of the cost of formal insolvency resolution process. Mediation may also help reduce the burden of the NCLT and the NCLT. In fact, in 2017, Singapore had similarly recommended mediation for insolvency disputes in an attempt to transform it into an international insolvency resolution hub. International, MF Global, and Lehman Brothers are 2 examples of important cases where mediation played a prominent role in the final resolution. Alternative resolution of such disputes will not only provide an avenue to the entities without facing an adversarial process, but can also result in a speedy and cost-effective resolution for creditors. We have to realize that these are not professional creditors, so as to say. They are people who have invested their life savings to be able to cherish the dream of owning their own house. In these cases, it becomes all the more urgent to ensure that the relief extended of the home buyer is not only effective, but also quick and least cumbersome. The suggestions of a pre-packaged insolvency resolution process under the IBC for micro, medium, and small enterprises is an interesting step in this direction. Internationally, pre-pack has been regarded as a corporate rescue method that combines formal and informal insolvency proceedings, a hybrid framework that resolves the stress of corporate debtors as going concerns with minimal state involvement. Cross-border insolvency as a concept has been in vogue in insolvency and bankruptcy sphere in India, especially since the government released a draft charter on the cross-border insolvency in 2018. The proposed cross-border framework will govern all applications seeking recognition of foreign insolvency proceedings, as well as applications from foreign jurisdictions seeking cooperation in India's jurisdiction. This landmark step is expected to redefine India's relations with the rest of the world and open up an interesting avenue to explore during the conference. I am certain that the conference will prove to be an important stepping stone in shaping India's insolvency regime in coming years, as there will be discussions on insolvency linked with technology, as also future insolvency. I believe that the technology, and specifically artificial intelligence, can be very helpful in analyzing, modeling, and predicting scenarios based on financial performance. The government too plans to develop an electronic platform which can handle several processes under the IBC, such as filing applications, delivering notices, storing records, etc. With these thoughts, I would like to congratulate Insolvency Law Academy for organizing this conference, which I am certain will benefit all the participants and enrich the field of insolvency. In any society, it's exchange of thoughts and free flow of ideas that makes it vibrant. This is all the more true when it comes to legal fraternity. I am confident that Insolvency Law Academy will continue to contribute towards turning the insolvency regime of India into a globally recognized story. Thank you and Jai Hind.